All right, let's set everybody back again. So keep going on with this journey that we got. So let's get it. 15 USC 1692E, false or misleading representations. Okay. So a debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt without limiting the general application of the foregoing. The following conduct is a violation of this section. One, the false representation or implication that the debt collector is vouched for, bonded by, or affiliate with the United States or any state, including the use of a badge, uniform, or facsimile thereof. All right, so this one, so basically a debt collector can't associate themselves with the United States or any state. All right, so let's say it's a debt collection company. I can't think of it right now, but um let's say if they use some type of government thing in their logo, their name, uh something like that. Let's just say the debt collector name was United States. All right, let's say they said USA Consumer Debt Collection Inc. Something like that. All right. Well, USA in your name is associate yourself with the United States. So that right there would be non-compliance violation of this section. But just pay close attention to like what the debt collector's name is, the logo that they use and whatnot. And if that would be false representation, making the consumer think that they're affiliated with the United States when they're not. Okay. False representation of the character, amount, or legal status of any debt, any services rendered or compensation which may be lawfully received by any debt collector for the collection of a debt. So for 2A, the character, amount, or legal status of any debt. So for amount, so basically with oil money, if I owe somebody money, it should be a negative amount, right? If somebody let me borrow $100, I owe them $100. I'm now negative $100 with that person. So if they're, you know, providing documents and such saying that you owe a positive amount, you possibly could use this and say, hey, that this false representation of this amount you sent on, because how can I owe a positive balance on something? If I owe money, then I should be negative. Legal status. You may have a debt collector saying that, they may be finna garnish your wages or do different things like that when they're actually not gonna do any of those things. Okay. Now let's moving on down. Number three, the false representation or implication that any individual is an attorney or that the communication is from an attorney. So basically that's just the debt collector, acting as something that they're not, to kind of scare the consumer. Number four, the representation or implication that the non-payment of any debt will result in the arrest or imprisonment of any person or the seizure, garnishment, attachment, or sale of any property or wages of any person unless such action is lawful and the debt collector or creditor intends to take such action. So the representation or implication that the non-payment of any debt will result in arrest or imprisonment or debt. So again, like I say, like you with the debts and stuff, if they say that you could be arrested, seizure, garnishment, and all this stuff, and they don't plan to take such action, and that action is not lawful, then that would be non-compliance violation of this section. Also, I haven't got into it, but some people could say like child support, saying that they're gonna arrest you, seize property and stuff like that. That would be a violation of that, with the child support situation, but I haven't experienced it yet, so I can't say from my own experience. But if you have, then comment down below, whatever, with this section here. Number five, the threat to take any action that legally cannot be taken or that is not intended to be taken. So basically, just making threats that they're not going to act on, that would be non-compliance violation of this section. Number six, the false representation or implication that a sale, referral, or other transfer of any debt, of any interest in a debt, shall cause the consumer to, lose any claim or defense to payment of the debt. become subject to any practice prohibited by this subchapter. Number 7, the false representation or implication that the consumer committed any crime or other conduct in order to disgrace the consumer. So again, when on debts, you're not breaking any crime, you're not doing any crime or anything like that. And again, the debts are alleged. So with this, they can't do anything to try to disgrace you or look down on the consumer. Uh, 8, communicating or threat to communicate to any person credit information which is known or which is known to be false, including the failure to communicate that a disputed debt is disputed. So here, number 8 is the easy violation here, non-compliance, because communicating or threatening to communicate to any person credit information which is known or which is known to be false. So again, like I mentioned in one of the other videos, generally they send you a debt validation letter, saying, hey, with the 30 days, if you don't respond, we'll assume all information is correct. And, it possibly can be reported to the credit reporting agencies. Well, if the consumer didn't verify this information or whatnot, how can this information be all the way true? Also, the information that they're reporting to a credit report is false because you don't have any 1 month terms with this credit reporting agency. Just because they so-called sent you a letter and say, if you don't respond within 30 days, which would be a month, and they, time go by, you don't respond, then they report it. That's not an agreement. 2 people didn't meet to have an agreement and say, hey, this is what it is. And who's to say that you even received that mail? They could have sent that mail to an address that you never lived at, sent that mail to an old address or whatnot. And also, they have no proof if they didn't send the mail certified mail or anything like that. So how do they even know that you received this communication? Or some of them may not even send you any communication and saying that you received it. So communicate or threaten communicate. So the credit reporting of a debt collection account, you could possibly use this to help get it removed because the information is false. I don't have any 1 month agreement with you at all. Okay. And also when it comes down to late payments and things of that nature, if you don't have any late payments or anything like that, then that would be false information there. Okay, so going down to number 9, the use or distribution of any written communication which simulates or is falsely represented to be a document authorized, issued, or approved by any court official or agency of the United States or any state, or which creates a false impression as to its source, authorization, or approval. So basically, just what this means is not to provide any documents that makes you think, is something official by the state, by the government to, scare you or whatnot. Number 10, the use of any false representation or deceptive means to collect or attempt to collect any debt to obtain information concerning a consumer. Again, just very simple. You could easily probably get non-compliance violation out of them trying to false representate. Number 11, the failure to disclose an initial written communication with the consumer, and in addition, if the initial communication with the consumer is oral, which means be by phone, in the initial oral communication that the debt collector is attempting to collect a debt, and that any information obtained will be used for that purpose, and the failure to disclose a subsequent communication that the communication is showing debt collector except that this paragraph shall not apply to a formal pleading made in connection with the legal action. So basically, anytime you talk to a debt collector, or if you see like mail from a debt collector, it'll always have like that little message on here saying, this this is a debt collector attempting to collect a debt information will be used for that purpose. So if a debt collector communicates with you and does not say this, then that would be non-compliance violation of number 11. Number 12, the false representation implicates that accounts have been turned over to an innocent person for value. 13, the false representation implicates that the documents are legal process. So, if they're trying to trick you into thinking, that it's something a legal matter and whatever the case may be, that's a violation. The use of any business, company, or organization name other than the true name of the debt collector's business, company, or organization. So this could be, let's say they're just acting as there's something that they're not. We'll just leave it at that. The false representation implicates that the documents are not legal process forms or do not require action by the consumer. 16, the false representation implication that a debt collector operates or is employed by a consumer reporting agency as defined by section 1681 AF of this title. So no debt collection agency is employed by a credit reporting agency and should not act as if they are. So here, as we went down this list, there's definitely a good amount of non-compliance and violations here. So again, wrap up 15 USC 1692E, false and misleading representation. So I'm just kind of let it go down real quick. I think I broke them down good enough as we was going through them. If I feel like I could break it down anymore, I'll comment down below. If you feel there's something I missed or that you want to add on to it, please comment down below. And thank you for watching this video. See you in the next one.